Today, our discussion will focus on general provisions. Article 1156 provides, an obligation is a juridical necessity to give, to do, or not to do it. The term obligation is derived from the Latin word obligatio, which translates to binding. It refers to a legal tie or bond that establishes a duty between parties. This duty compels one party to render something to another, whether it involves providing a tangible item, performing a specific action, or refraining from certain behaviors. In essence, obligation creates a framework of accountability and responsibility, ensuring that individuals or entities fulfill their commitments in accordance with the law. Concept of juridical necessity. An obligation is a legal requirement that must be followed. If someone fails to meet their obligation, the court can step in to make sure it gets fulfilled. If that's not possible, the courts can also order compensation in the form of damages to make up for the failure. Essentially, obligations are important because they help ensure that people keep their promises and responsibilities. This is the essence of juridical necessity. What are then the essential requisites of an obligation? The essential requisites of an obligation are fundamental elements that must be present for an obligation to exist. They are active subject. This is the party entitled to demand the fulfillment of the obligation, commonly referred to as the creditor or obligee. They have the legal right to enforce the obligation. Passive subject. This refers to the party who is obligated to perform the duty, known as the debtor or obligor. This individual is responsible for fulfilling the terms of the obligation. Prestation. This is the subject matter of the obligation, which can include giving something, doing an act, or refraining from doing something. It defines what is expected from the debtor. Efficient cause. This represents the legal tie that binds the parties involved in the obligation. It can be a contract, a law, or any other legal basis or source of obligation that establishes the relationship between the active and passive subjects. For an obligation to be valid, all four essential elements must be present. For instance, consider a loan agreement. The lender is the active subject who has the right to ask for repayment. The borrower is the passive subject who is responsible for paying back the loan. The money lent is the prestation, which is what the borrower must return. The loan agreements serve as the efficient cause, providing the legal basis for this obligation. Together, these elements create a binding obligation that ensures both parties understand their rights and responsibilities. Next, we will explore the different types of obligations based on their subject matter. Obligations under Article 1156 can be classified based on their subject matter into two main categories. Real obligation. This type of obligation involves the delivery of a specific thing or property. The obligor or debtor is required to provide a tangible item to the obligee or the creditor. For example, if someone rents a car, they have a real obligation to return that specific car. Personal obligation. This type focuses on actions rather than things. It can be further divided into positive personal obligation. The obligor or debtor is required to perform a specific act or service. For instance, a contractor has a positive obligation to build a house as agreed. Another example is when a landowner who sold his property to a buyer is obligated to provide an easement or right of way. Negative personal obligation. The obligor or debtor is required to refrain from doing something. This includes an obligation not to perform certain actions, such as not trespassing on someone else's property. A donor of land may require the donee or beneficiary not to sell the land donated in any way. Lastly, we will delve into the essential elements of a legal wrong or injury. The essential elements of a legal wrong or injury include the following. Legal right. There must be a legal right held by the injured party, the plaintiff or creditor. This right can arise from various sources, such as laws or agreement. There must be a corresponding legal obligation on the part of another individual, the defendant or the debtor, to respect that right and not violate it. The defendant must have committed an act or omission that violates the plaintiff's legal right. This breach leads to an injury or damage experienced by the plaintiff. The violation of the legal right must result in actual harm or damage to the plaintiff, which can be physical, emotional, or financial. These elements are crucial for establishing a cause of action in case involving legal wrongs or injury, as they demonstrate the relationship between the rights and obligations of the parties involved. An example of a legal wrong is breach of contract. This occurs when one party fails to fulfill their obligations as outlined in a legally binding agreement, causing harm to the other party. For instance, if a contractor does not complete a construction project as promised, the property owner can seek damages for the financial losses incurred due to this breach. Another example is negligence, such as in a car accident where a negligent driver fails to stop at a red light and collides with another vehicle. The other driver has the right to safe travel and reach his destination point. The other one who caused the collision has the correlative duty to respect that right. The negligent act of the driver is failing to stop at a red light. In this case, the negligent driver can be held legally responsible for the injuries and damage caused to the other party. So there you have it, the general provision, the definition of obligation, understanding juridical necessity, the essential requisites of obligation, and the types of obligation based on the subject matter. These topics provide a comprehensive understanding of obligations and their significance within the legal framework.